And I want to begin by thanking all the viewers of Republic, the millions and millions of people who have responded in a huge manner to our campaign to save the Aravallis. Unfortunately, to them, I would say that nowadays, if you question government policy in public interest, and you remind the government that it should be the government which should be thinking about public interest and not corporate interest, that it should be the government which must think about the people and not for corporates, you are told that it's a political conspiracy. These are people who are either blinded by arrogance or motivated by vested or personal interest. Republic, as a media network, an independent media network, we do our job, we couldn't care less. What I do know is that our position on Aravallis has resonated with you, the people of India. And I would once again like to ask a simple and fundamental question tonight. A 2 billion year old mountain range is redefined 3 days before a Chief Justice of India is about to retire. I'm not drawing any link, but I'm just stating a fact. Now, my first question tonight is on the principle of why a judgment of the Supreme Court of India, no less, does not need to pay heed either to domain experts or to the amicus curiae defined as the friends of the court. The job of the Supreme Court of India is not to consider all points of view and then agree with the government. The Supreme Court of India has a right to take that stance. Technically, nobody can question it. But there is something called logic, sensitivity, and precedent. The Supreme Court went against the amicus curiae, the friend of the court. And I want to ask them, because in para 30 of the judgment, it is clear that the amicus curiae had stated in his submission that he was not for this committee's definition, that the committee's definition of this 100 meters or less mining can happen would endanger the environment and the ecology of the mountain range. I have the courts, I have the documents, it's all on paper, ladies and gentlemen. And the nation wants to know tonight, why did the courts not pay heed to their own legal friend appointed by them? Further, in para 28 of the judgment states that Senior Advocate K. Parameshwar, the amicus curiae, opposed the new definition, this 100-meter bizarre, crazy rule. He argued that the earlier FSI criteria better preserved the ecological integrity of the Aravalli ranges. Why was the view of the friend of the court not taken into account? Now, viewers, these are questions the government should be asking. I hope the government knows the difference between the Ministry of Environment and the Ministry of Mining. It is not for the Ministry of Environment to put out what I found today to be a weak and unconvincing defense by Bhupender, Yadav, the Environment Minister, who I think is himself not sure of his own arguments. Absolutely not sure. The question Mr. Bhupender Yadav should answer, why did the government as well as the Supreme Court go against the forest report? The facts are with me. Not only did the courts go against the amicus curiae, they also went against the Forest Survey of India. As stated in para 27, the Forest Survey of India had defined the Aravallis in 2010 as, and I quote technically, under 1 slope greater than 3 degrees, 2 foothill buffer equal 100 meters, and 3 the interhill distance or valley width 500 meters, and 4 the area enclosed by the above defined hills from all sides. Now, this is information given by domain experts, by people who know, by subject matter experts, people who know enough about the subject of ecology and forests and mountains and geology to be able to provide expert opinion to the government, to the Supreme Court. Why would the courts take a contrarian view to both the amicus curiae as well as the forest report and give a judgment 3 days before, ladies and gentlemen, the Chief Justice of India is to retire? What is the tearing hurry to redefine the Aravallis? And this is logic, ladies and gentlemen. This is logic. For anyone to come out and say right now that we have the right to do something. I want to tell the courts, I want to tell the government, just because you have the right to do something does not mean you end up doing something, regardless of political or public backlash, which goes against national interest. I'd like to tell the government once again that in national interest, in public interest, revisit your own positions. Do not use this trapdoor logic that we managed to get the government to agree with our positions. And hence, we'll shoot off the shoulders of the Supreme Court to whatever we want. To the Supreme Court, I would say that empathy and conscience are extremely important. This whole attempt to create this central illusion that we will not allow mining doesn't make sense. Ladies and gentlemen, the new definition of the Aravallis is a de facto mining enabler. A de facto mining enabler. This is going to destroy the Aravallis. It's going to destroy the ecology forever in a manner the government and future governments will not be able to change. This whole idea of sustainable mining in its definition is an oxymoronic statement. I want to ask the government, who benefits from what you are trying to do? Who benefits? I want to ask the central government, which is very sensitive to criticism. Who benefits? Do the politicians not realize that Republic has accessed the 2,334-page additional affidavit filed on behalf of the Ministry of Environment, Forest and Climate Change to the Supreme Court of India, purportedly in compliance with its order dated 9th May 2024? A close reading of this affidavit exposes a direct contradiction between the government's public claim of protecting the Aravalli range and the policy intent recorded in its own sworn admissions. Why is the government and the Supreme Court so keen for mining? And what about the principle of precaution? There is a legal principle of precaution, ladies and gentlemen, wherein matters of law and matters of law connected to environment, you generally steer and move towards precaution. Don't do anything today which is going to be irreversible for the ecology and environment in the future. In this case, all of the above have happened. And the people of India have a right to ask the questions that we are putting forth on their behalf tonight. And let me tell the government, the people of India are watching. A one-day, two-day rehearsed and unconvincing defense is not going to be the end of this public battle by the people of India to reclaim their rights in matters of ecology, because it matters to the people. And therefore, and only therefore, it matters for Republic.